Okay, Attorney Steve Vondran, we're back. This is video 3 in a 3-part blockbuster overview. This is general legal information only, not legal advice. General legal information only. The facts and the procedures and the laws and the rules, everything may have totally changed since I've done this video, so bear that in mind. And I know you know that. Okay, so we talked about the complainant's burden of proof, coming forward with all this evidence, the valid trademark or service mark, the evidence of bad faith registration and bad faith use of the mark, of the domain, and no legitimate rights in the domain. If you can prove those three things, you just might be able to talk that panel, whether it's WIPO or the National Arbitration Forum, you may be able to talk them into canceling the trademark, or canceling the domain and transferring it over to the trademark owner. Okay, in this case we're using the company Best Buy and a potential cyber squatter who buys the name bestbuyrebates.com or .net, .org, whatever. Okay, so we talked about filing the complaint, serving it on the other party. Now we're talking about, well, what are some of the defenses? Do they automatically win when they file just because they're bigger and have more money than me? They automatically, and they have a federal trademark, they automatically win? I can't go buy domain names that are legitimate just for legitimate use? Well, you do have defenses. Let's talk about those. You have, as I mentioned, generally speaking, you're going to get a response period. Let's say it's 20 days to file your response here and get it in and tell the judge your side of the story. Tell them what happened and tell them this isn't as clear-cut as it seems and here's why. Just as they produce their complaint and declarations and evidence, you do the same thing. If you got your declaration, pictures of your web pages, things that you're doing with your brand, legitimate uses that you're making of the domain, you present all your evidence, get it before the panel, let them evaluate this, okay? In a way, it's a lot like a motion for summary judgment in a state court case or a federal court case, where you're giving the judge as much evidence, or the panel, as much evidence as you can so they can make a determination. Should you be allowed to proceed with your domain, or is it time to divulge that domain and send it back? Disgorge it is the word we like. Disgorge that domain. So these are the things that they're going to look at. Defenses. One thing they call is the extraterritorial defense. I'm a company in United States. How on earth would I know that some company in Germany had the similar trademark or this or that? I had no way of knowing. How could that be bad faith? It's just, I mean, you know, I'm from there, you're from there, I don't know about you, you don't know about me. There's just no way. Extraterritorial, we're too remote. That's something you can raise. And by the way, none of these mean you're going to win. These are the arguments that you make, okay? Everything you do in law is a legal argument. You make your point, you get in, you give out, you give some evidence, you get in, you get out. Extraterritorial. Another one, fair use, is that I'm making a fair use. It's a criticism site. I'm commenting on your brand. I'm criticizing your brand. It's Best Buy product sucks. And everybody knows it's not Best Buy products. No, Best Buy would never do that. But it's my First Amendment rights. It's my fair use rights to speak my mind. Okay, that's something that can be raised. Parody is another one. Parody. I'm just making fun. This is all just in good fun. It's a parody. Okay, we'll talk about other videos where we talk about parody law and how parody is it's a very fine line. It's like they say, parody is like shooting at the king. You better be good, okay? Because if you miss, you're in trouble, okay? That's basically what parody is. In a nutshell, parody, you need to conjure up the original. You need to create something new, and it needs to be, you know, not so, if you read a lot of parody law, the malicious attacks on the famous brands are probably going to get you in trouble. Not to mean that you can't try to parody a big brand, but I'm just saying that's kind of how it goes. So parody as a defense, it's tough, but if you're, remember with parody is you have to be criticizing and commenting on the original work that you're parodying, okay? And watch my parody videos, Vondran on parody. That's another good set for you to watch. No likelihood of consumer confusion. You say, Your Honor, this is crazy. I mean, I'm over here, I am Best Buy Rebates, clearly not them. I'm using disclaimers on my websites. Mine looks totally different from theirs. The domain is, you know, I don't even get it. It's that no consumers are likely to be confused here. So, you know, that's basically getting to the point of showing that there's some sort of confusing identical domain name or confusing similarity. It's just not there. It's not there, Your Honor. I mean, you know, nobody's being harmed or injured here. Okay. Part of that analysis gets back into the trademark factors and what's distinctive, what's not, where you have what they call arbitrary and fanciful names. That's a name where it's just literally pulled out of the hat. Like something like Nike.com is a just arbitrary and fanciful name. So it's kind of hard to argue if you have NikeRebates.com. It's going to be hard to argue that, you know, that's just a dictionary word, Your Honor. Anybody could use it. So these are the factors that are going to get weighed in that analysis. And this is what judges do. They weigh things. So now you may say, well, it's just a keyword. It's just a dictionary name. Okay, now you're going to have a little more traction, okay, because now you're talking on the low end of the distinctiveness scale, the low end where you say, it's just a word. I mean, they don't own rights to the word, for goodness sakes, right? So that's where you get your distinctiveness scale in there. Let's knock that out. If you have any legitimate uses, remember I said they had to prove all three, 1, 2, 3. If you have legitimate uses, you bring those forward. You know, I own Best Buy. I'm in a completely different field. I'm over here, and this relates to some consulting services. It's totally different. I have a legitimate use in that. Use of disclaimers, we just talked about that. Latches. Latches is basically waiting too long to bring your dispute. Okay, there is case law out there in the UDRP forms where waiting too long. There was a company that waited over 14 years to bring a claim against the domain holder, and the court said, you waited too long. Why didn't you bring this earlier? Something's fishy here. I don't understand. And the court said, no, we're not going to transfer the domain because of latches. And then prior use. As I mentioned, if there's a company out there that bought a domain before I bought it, and then my brand was established, I can't go back and say, well, they bought their domain 5 months before I bought mine, and that's UDRP. You're going to have a hard time winning on that kind of claim. So prior usage, these are things to look at. So basically your process, as we mentioned, you know, 60 days in general. You're going to have your complaint, your response, a period for additional reply, and the court may or may not, the judge panel may or may not allow additional supplemental materials to be filed. So something to bear in mind. Check your rules if you're not sure. Okay. We haven't talked about settlement. These cases can settle. If you're talking about losing $1,000, $2,000, $5,000 in filing a domain dispute, you may want to settle the case. Maybe the brand owner says, I'll tell you what, just give me $5,000, we'll settle, and I'll buy the domain just the same, keep it all confidential, and let's just move on here. So it really just depends, but you do have, just like every court case, opportunities to settle, cancel your arbitration. If you're in WIPO, the World Intellectual Property Organization, you may get a partial refund. Okay, so bear that in mind. And then finally, you're going to have your decision come out. Your decision is going to either transfer the domain back to the trademark holder, or the complaint could be denied, which is smaller, more rare, but the court could say, no, I'm going to deny the complaint, sorry, you got nothing. Or possibly cancel a domain where you have like a phishing website. The court could just cancel the domain. Finally, you have, and we talked about these factors, you have a right to appeal. You have a right to appeal the decision, either party, winner or loser, to federal court. You also have the Anti-Consumer Protection, Anti-Cyber Squatting Consumer Protection Act, which a trademark holder could use. We're going to talk about that in a separate video, but you could have up to $100,000 per damage per domain, statutory damages, in bringing an action like that. You can seek a preliminary injunction in the ACPA case and cost an attorney fee. So this is powerful. If you lose, you may have rights to go there and prove your case. It's going to take longer, but that's something that you have. And then you also have, believe it or not, there's going to be a video for.